Good afternoon, everyone. We are pleased to have so many of you joining us today for resolution techniques for construction and personal injury cases used in recent catastrophic events. If you'd like to minimize the GoToWebinar dashboard, just click the orange arrow to the left of the control panel. All attendees are muted for the presentation, but if you have a question you'd like to ask, please go to the questions drop-down on your control panel. We're collecting all questions to be answered after the conclusion of today's webinar. You'll also notice a handout you can download in the drop-down menu. We want to thank the University of Florida Levin College of Law Institute for Dispute Resolution for co-sponsoring our CLE webinar series. Now to our presenters. We have Barry Davis. He's a Florida Supreme Court certified mediator, and he performs results-oriented mediation, evolving from decades of serving as lead trial counsel to both plaintiffs and defendants in hundreds of complex construction and commercial disputes, insurance coverage and bad faith cases, and high-profile personal injury and wrongful death matters. He and his team devised and negotiated the very creative $103.5 million settlement involving more than 40 parties and insurers in the mass tort FIU bridge collapse litigation, where he served as lead counsel for the bridge designer. Go right ahead, Barry.
Good afternoon. I'm pleased to be joined by Mark Boyle. Mark is both a colleague and a friend, and he's been the managing partner for Boyle Leonard Anderson since 2008. Mark concentrates his practice in insurance recovery, including coverage denials, claim presentation, bad faith matters, and appeals. Mark focuses on the representation of business policyholders in large construction and insurance disputes and catastrophic losses. He's presented oral arguments in the appellate cases before the 2nd DCA, U.S. Court of Appeals, the 11th Circuit, and the Florida Supreme Court. Mark also worked with me as part of the team that resulted in the FIU bridge collapse settlement. We worked very closely together on that and other matters, and we're both pleased to be here. Good morning, Mark.
Good morning. So I want to first thank Barry for inviting me and congratulate him on joining the Upchurch, Watson, White, Max folks. The group that Barry is now part of has literally settled hundreds of millions. It's probably billions, but I don't want to exaggerate for effect of my clients' cases. And I know for a fact, because I've talked to Barry about it, he's much enjoying mediating as contrasted with the high blood pressure that constitutes litigation.
Well, thanks, Mark. Here's what we wanted to do. Mark and I got together and we decided that since I was so deeply involved with Mark in the FIU bridge collapse case and had some representation in the Champlain Towers case, Mark as well, we wanted to discuss those issues that came up and the challenges in those cases with everybody so that we can share what occurred and how it affects the types of cases that are out there now, not necessarily catastrophic cases, but what we learned in those cases and what we did in those cases and the challenges that affect your cases and the cases that hundreds of them that I'm settling now as a mediator and Mark's involved with as counsel for his clients as well. And we're happy to take questions, as Kathy mentioned, that we'll answer at the end. So what we wanted to do is just briefly describe what the challenges were that we had in those cases. And Kathy, if you could go to preparation, the next slide, and the next slide after that. What we were faced with in the FIU pedestrian bridge collapse settlement challenges is we had 40 parties and we had issues of insurance coverage. We had issues of liability that were being contested. We had issues of not enough money by certain defendants. We had issues of indemnity claims and additional insured claims, and frankly, jealousy. You know, the FIU bridge designer, Fig Bridge, who I represented, was found by the NTSB to be one of the primarily responsible parties. So we had issues of when we went into negotiation, other parties pointing fingers, saying, well, gee, the NTSB found at least preliminarily that you were primarily responsible, so you ought to pay more money. The problem is that when we looked at all the money available, there wasn't enough from the bridge company anyway, in terms of insurance coverage. And they were a relatively small company. So the challenge was, how do we put together enough money from the available parties and then do it in a way that there was no jealousy among the parties, and then convince on the plaintiff side them to be able to come up with a resolution among themselves as to how the money was going to get divided. So we went about taking that challenge and then also getting rid of all the cross claims and indemnity claims and the various issues that came up. And as we go through the presentation, we'll tell you how that was accomplished and how some of those principles that we did in those cases affect cases now that we deal with now, primarily in mediations to resolve cases. Mark, and you had some of the same issues in the Champlain Towers case?
Yeah, so it was my solemn duty to be the coverage attorney for Michael Goldberg, who I can't say enough good things about Michael and his service as the receiver appointed by the judge to represent the Champlain Towers. Many of the same types of issues occurred. We settled the two cases differently. We'll probably talk to you about some of the differences and how they were handled. One of the biggest ones is that Champlain Towers involved almost no in-person mediation sessions, not just because of COVID, but it was a strategy by the judge and the parties and the mediator in that case. Whereas in FIU Bridge Collapse, I have never spent more days in the mediation process in any case I've ever been involved in than we did in FIU Bridge Collapse. I bet we spent, Barry, maybe literally 30 or 40 days in actual mediation sessions, I think.
And that doesn't even count the late night calls that we would have with insurance companies directly and the lawyers and the plaintiff's counsel. It wasn't endless. It just felt like it at the time, and the persistence that was necessary to get insurance companies essentially to offer more money and insureds to offer more money and plaintiffs to talk about how that was going to get resolved. So yes, it was a process that took many months to get done.
That's one side of it, and was obviously where most of our work was. But you had an alternative issue, which is there were some carriers who threw their money up within minutes in both FIU Bridge Collapse and Champlain Towers. And especially where they had declining balance policies, you had this huge risk that the continued litigation was going to eliminate the limited pool of money that was available to get these cases settled. And there was already a limited pool of money in both circumstances, and that was a core issue. For whatever reason, Southeast Florida, I think you folks in Miami like to call yourselves South Florida. We call you Southeast Florida since I'm from Southwest Florida. You've had a lot of these tragedies with the Champlain Towers, FIU Bridge Collapse. I also got to work on the Miami-Dade garage collapse. Very similar issues, and Miami's just had a lot of misfortune around these cases in the last 10 years.
So some of the issues that were faced that also come up in both personal injury cases as well as construction cases that came up, or commercial litigation matters that came up in specifically the FIU case. There were issues of sovereign immunity. There were issues of vicarious liability, and that affected whose insurance policy was going to cover. There were issues of the Slavin doctrine. In other words, if the property owner accepts the contractor's work with the patent defects, then that provides immunity. So that issue was litigated. There was the Spearin doctrine that came up as well in that case. Again, a general contractor would not be liable for defects in the plans and specifications furnished by the owner if the general contractor constructs the project pursuant to the plans and specs. And of course, with anything else, there's exceptions and discussions. That was another issue that came up and comes up many times in construction matters. There was the government contractor defense. For example, there was a private firm that was hired by the FDOT to do inspections that the FDOT would otherwise have done, that was requesting sovereign immunity. Government contractor defense is going to shield the contractor from tort liability for products manufactured to government specs if the contractor warned the United States about hazards not known to the contractor but not known to the United States. There were some of those issues. And then there was also, of course, the ever-present economic loss rule. Next slide, Kathy. And there was the government contractor defense that people would file both contract claims and negligence claims, but the economic loss rule bars a negligence action only in circumstances where the parties are either in contractual privity or the defendant is a manufacturer or distributor of a product and no established exception to the rule applies. Well, there are exceptions from time to time. And then we had indemnity issues that were ever present in many, many cases that we see, that I'm seeing, not just in personal injury cases, but also in construction cases as well. And those indemnity issues, both common law as well as contractual, had to get resolved as well. And that affected also insurance coverage issues. Mark, you may want to talk about that a little bit on how the indemnity issues are affecting insurance issues that had to get resolved and also need to be resolved in today's cases when we're doing mediations and preparation.
So construction claims are filled with risk transfer issues. Most typically, everybody's required to purchase insurance. They're required to give indemnity, particularly lower tier contractors to upper tier contractors. And lower tier contractors typically pledge their own insurance towards upper tier contractors, making the upper tier contractors additional insureds. That risk transfer and who has to pay first is a common feature of almost every construction case. But when you have one of these mass tort situations, it creates a settlement blockage point, because a subcontractor carrier who may want to tender their money towards the settlement of certain claims is afraid to do so for fear of both exhausting the limits and not protecting their insured from an indemnity claim, and for fear that under Florida's robust bad faith law that they failed to get all of their insureds out of those cases. And I think one of the things for sure that Barry and I agree on is both the Champlain Towers and the FIU bridge collapse ended up with mechanisms that allowed us to avoid these problems. So the FIU bridge collapse, the primary contractor declared bankruptcy, and that contractor both had incoming indemnity rights and outgoing indemnity obligations and these additional insured rights, but it was the fact that they were in bankruptcy and could obtain a bar order that functionally allowed the case to settle. It was only with the promise of a bar order that a lot of people would put up their money for fear of other extraneous claims, claims we didn't know about, hadn't heard about, cross claims, indemnity claims, additional insured claims could all get resolved. There was a similar mechanism in the Champlain Towers. There, the plaintiffs brought their claims as a class. And under class action law, the court has broader power to issue bar orders, which just can accomplish more than you can accomplish functionally with a release. They can affect non-parties as long as notice is given. And I think if you ask anybody in the Champlain Towers case, they would recognize that in the absence of that power through the class action process, the case just couldn't have been settled, especially on the timeline that it was, the 1 year timeline. The defendants tend not to like these devices, class actions particularly, but when you get to really big girl, sophisticated cases, defendants eventually realize that these devices can really be to their benefit. And I think depending on how big your case is, that's one of the ways you've got to look at it. How can you make sure all the defendants get protected? Because that's what's going to get their money up on the table, particularly the insurers. Insurers only pay money when they're not going to be dragged back into circumstances.
Here's what a bar order is. A bar order is this interesting ability of a bankruptcy judge to give significant creditors or debtors the opportunity to get the same protection as the bankrupt. So in other words, when we put together the $103.5 million settlement among all of the defendants that went to primarily the people who were injured, the bankruptcy judge and the creditors committee said, thank you. That is a significant amount of money. And the judge said, okay, to everybody who has contributed to this, I'm going to issue a bar order. Nobody's going to be able to sue you anymore. Just like in a bankrupt, when the bankrupt files a bankruptcy and they make a whole reorganization plan, nobody can sue them anymore. But when people come together as contributing to this creditor's pool of money that's going to go to these people who are injured, who are going after the bankrupt, then the bankruptcy judge has this huge discretion to be able to say, this money is so significant, it's going to be satisfying the creditors. In other words, all these people who were injured. So I, as the bankruptcy judge, have the discretion to be able to give you, all of you contributors, the same benefit as the bankrupt. So if you have somebody who doesn't participate, like another defendant who doesn't want to go along with it, or another plaintiff who happens to come later and wants to file a lawsuit, it's now barred by the bankruptcy judge. And that's what happened in the FIU case. But it took putting together this big sum of money, getting the creditors committee to say, you know what, that is great, that's sufficient for us, we agree. And so that's what happened. As far as I would say the number one rule that we were able to do, and what I encourage in preparing for mediation, is to find out where all the money is. Find out what all these insurance policies exist. I did the mediation recently in the Call Me Gabby case, which is a restaurant on Miami Beach, where someone was in a car and hit the accelerator rather than the brakes and mowed down a bunch of people who were sitting out on the terrace having dinner. And there were about 7 or 8 plaintiffs, some minor injuries, all the way to death. And there were a number of defendants. And we got into the mediation at first. And the way the mediation went was to use it as a discovery vehicle to find out where all the money was. Who was insuring whom? Were there additional insureds? Would it cover for indemnity claims? And until that was known, and you'd be surprised at the number of mediations that I get involved with where that isn't known and should be. So I try to do that in having confidential pre-mediation calls so that when you go into the mediation, all of that is known and on the table, because without it, it makes a mediation very difficult to settle. So that would be rule number one, is to find out where all of the money is, and typically it involves insurance, and all of the cross claims, all of the indemnity claims, the additional insureds, and get all of that done prior to mediation, because it's going to make the mediations and settlement talks go much more productively. Mark?
I want to add a little point related to the, I'm just going to use the term that the media is using. Don't take it that I'm agreeing with the term, the tort reform bill that passed recently. So Barry talked about how you resolve those cases. Florida has probably the most well-developed body of law of what a liability insurer's duty is when there are multiple claimants. It all comes from an older case called Farinas. And what the case basically says is the carrier has to diligently investigate, figure out all the claimants, figure out which ones are the most injured, try to settle all the claims, and if they can't settle all the claims, then pick off the claims that create the most exposure to the insured. Well, the legislature has changed the way those Farinas cases will get resolved, and it gives the carriers two options. So you're going to see this, and you wonder how this might have worked in either Champlain Towers or FIU bridge collapse. The carrier has the right to do one of two things. They make clear that they're prepared to give their policy limits up. And if they can't reach an accord with the parties, they can just tender the money into the registry of the court, one, or reach an agreement with all the claimants that the claimants will resolve the claims in a binding arbitration, and that they'll get presumably what would be a pro rata distribution, depending on the arbitrator's findings. My guess is Barry is going to be doing some of these arbitrations. It'll be a part of his job in the near future.
Yeah, I mean, I've done a lot of the Farinas hearings, and just because that legislation, the way I see it, is passed on the insurance carriers being able to put the money in the court and then having a binding arbitration, isn't going to preclude the parties from getting together and trying to resolve in a amicable manner rather than going directly to the binding arbitration. Because even though it might get insurers off the hook, it still doesn't get that money divided up. And so the question is, how is the process going to work to really get the money divided up? And when, as you mentioned, we do the Farinas hearings, again, there are pre-mediation calls to assess the value of the different cases, and then to try to get it resolved among the plaintiffs. And sometimes, like was done in the FIU case, you have private discussions with the different plaintiffs and rank the cases largest to smallest. And when someone isn't being reasonable, when there's that pool of money and the others get together to try to get it resolved, the risk to the plaintiff who doesn't try to get it resolved is that he's last man out and doesn't get anything. And that's the same risk to the defendants who don't want to participate in a settlement, is that guess what? Everybody gets it resolved, as has happened in the FIU case, except for one defendant. And then that one defendant, of course, the spotlight from the plaintiffs is going to go directly on that defendant. And what happened in the FIU case is that everybody, all the plaintiffs, agreed on how to divide it by doing a binding arbitration. And then all the defendants agreed to participate except for one. And that defendant continued with all the plaintiffs, or most of the plaintiffs, continuing to sue that one defendant. And guess what happened? The judge permitted an amendment against that one defendant for punitive damages. That resulted ultimately in that defendant settling. The settlement was confidential, so I don't know how much it was, but my guess is that it was significantly more than what that defendant could have contributed to participate in the global settlement. So that idea of being last man out, either on the plaintiff side or the defense side, is a risk that we try to convey during mediations as to why they should participate with everybody else. So Kathy,
almost always the last person left in one of these cases pays a premium to get out. Sometimes they vindicate their entire position and get out. They get a summary judgment, they win a trial. But I would say 85 times out of 100, that person pays a premium. Don't be the last party in one of these large multi-unit residential cases, particularly if there's a bodily injury component. It's not going to end well for you.
yeah, even when there's only 3 or 4 defendants,
That's right.
that it's a problem when that happens for that plaintiff or that defendant. So we try to convey that as part of the mediation. Kathy, can you go to the next slide, preparing for mediation? Next one.
When we go to that preparing for mediation, I'm going to say something that a mediator told me that I thought was very wise, which is when you graduate from law school, you'll be lucky if you got some oral advocacy training. you'll probably get some about how to act in court or how to deal with the jury, but we don't really train lawyers how to present their cases and negotiate their cases at mediation. That's actually a failing of the system, particularly given the kinds of cases we're talking about. 98.5%, I would think, of big girl construction insurance disputes get resolved through or at directly in the mediation process. Barry's going to keep after you after. So I want to make sure, I want to make clear, I don't mean just in mediation. We do not do a good job of teaching lawyers how to be good in mediation and how to change what the other side is thinking about their risk. And that's probably a failing of the system and probably law firms generally.
So we're up to preparing for mediation. And the goal, obviously, is to set the path to resolution. Right at the beginning, have that focus. And if you go to the next slide, we're going to talk about how to set that path. What I try to do is have private, confidential communications before the mediation with each attorney and not repeat one single word of it, because I'm very interested in getting each attorney's perspective on how they see the case. And it helps not only for mediation, but you know, when you get a deadline, you got to get ready for trial, you really come in and laser focus on it. So once you have the attorney perspectives, the attorneys are focusing on how to get to that goal. The attorneys are then preparing for, if it doesn't settle, where they're going to go to mediation and trial, what presentation is going to be made. Because I hear often, well, I don't necessarily want to disclose everything I have during the presentation, so how much should I disclose and how much shouldn't I disclose? And that's part of preparing for mediation, because it depends on the case and it depends on how far along you are in the case as to how much you're going to disclose during mediation. Most of the time with our discovery process, the other side's going to know what you have anyway. So disclosing things during mediation where there's a reasonable chance of settling is usually the way the mediations go, and certainly contributes to getting the matter resolved. Next slide. I think we covered this. Where's the money? Because at the end of the day, that's what it comes down to. And so we look at things, and Mark, you can add to this, but I made a list of things on where's the money. Certainly you have policies of insurance that hopefully everybody gets before. Self-insured retention issues. Where are the pressure points going to be? The insured with the self-insured retention will certainly be pressured by the insurance carrier to use the insured's money. The excess insurance company is going to come in and want them below to settle because they want to protect their own money. There'll be personal counsel that comes in. So figuring out where all those pressure points are in advance of the mediation is very helpful. Policy triggers, and you can probably talk more about that too, Mark, as to which policy is triggered under which circumstance. Who has good insurance policy defenses? The financial ability of the insured to pay or not pay. Competing insurance policies, and you may want to add to that as well.
So all of these tragic circumstances that we're talking about, Miami-Dade College, FIU bridge collapse, Champlain Towers, all involved multiple disciplines of insurance. And each of them involved large elements of dispute over which one had priority or not. Probably this mattered less in Champlain Towers because pretty much all the insurance for everyone, with the exception of one party, was pretty much put up on the table. Lawyers who focus mostly on injury claims, which is who I assume is most of the attendees here today, you get very focused on liability insurance. But the truth is, when you have a giant social problem like these cases that we're talking about today, every form of insurance you can drag to the table is important. In the Champlain Towers, there were multiple layers of property insurance, directors and officers liability insurance. The law firm that represented the Champlain Towers, they were sued. Their malpractice carrier was one of the carriers that contributed towards the settlement in the case. The directors and officers liability policy for the Champlain Towers, they contributed. And as you think about these problems, when you're in the case, one of the things I think you really have to think about is that different types of these policies have different obligations with respect to their defense. In the Champlain Towers, for example, I represented the towers themselves through their receiver, Michael Goldberg, who I mentioned before. They had a general liability policy. Well, a CGL policy typically has a defense component that is outside of limits. And that defense continues even if the money is tendered towards a settlement. You can eliminate your defense obligation only by paying a settlement or a judgment. Just offering the money doesn't eliminate the defense obligation. So the primary carrier in that case for the CGL, for the Champlain Towers themselves, they were stuck defending the entire matter. And knowing who has those defense obligations and where they're going and whether they're diminishing coverage or whether that's creating leverage to help you to get them to pay more money, all that is relevant. And I think Barry said something important about the trigger. Champlain Towers is a good example. We tendered this loss back to the CGL carriers 10 years back in time, the entire period of the statute of repose. And all of those carriers made a contribution towards either the defense or indemnity or both as a component to get released. We tend to focus on the policies that were in effect and the actual date of loss, and that probably matters the most in most liability insurance settings. Don't be afraid to cast a wide net, particularly in construction where you have latent defect problems that have been happening over time.
You know, what we've seen is, and what we saw in FIU and I see in other personal injury cases as well as construction cases, are lawyers are pretty good at alleging complaints that may fit within different coverage policy language. So the insurance carriers then are put in a position of saying, well, the trigger of at least the duty to defend is based upon the four corners of the complaint. So then the question becomes, do they defend the case? Do they not defend and deny coverage? And as Mark said, on professional liability policies for an architect or engineer, that's going to cover them for that professional liability, but the general liability policy has an exclusion for professional liability. But what happens is there an increased risk when there are allegations of the complaint that kind of fit within the language of both policies. And many times what I see, and actually what I saw in the FIU case and in other personal injury matters, is that both policies come in, there are reservations of rights, and then the insurance carrier has to sit down and say, well, I'm defending the case. What are the economics of it? What are the risks? And that all goes into the thought about settlement and where the money is. And that happens quite often in history of what I do. So that's some of the thoughts concerning, again, we're back to where's the money. So go to the next slide, please. There are also many non-monetary issues that come up in both personal injury as well as commercial cases. People request confidentiality, non-disparagement agreements, dismissal and mutual dismissals with prejudice. In FIU, we got cross dismissals and mutual releases among all of the defendants because nobody wanted to be left just having the plaintiff settled and still continuing with the cross claims that were made. There are assignment of right issues, covalence issues, where you can assign rights of being able to the plaintiff to be able to sue the insurance carrier which are now somewhat affected by the new legislation. And then there are exceptions in the release. I'm going to release everybody, but a particular defendant. I put the word monument because part of the settlement in the FIU case was that a monument would need to be erected at FIU to the people who were killed, or at least to one or more of the people who were killed. But what are you seeing, Mark, on the assignment of rights issue as a result of the new legislation?
So it's hard to understand how this will affect everybody. As it sits right now, you won't be able to assign the attorney fee rights that used to come with 627-428. And the governor signed it. So I think that will place some limit on smaller cases being assigned and their insurance rights and the covalence rights. But the kinds of cases that your office and my office handle where there are millions of dollars at stake, I always say the attorney fee rights are the tail on the dog, and they're not going to decide whether if you're going to enter into a $15 million covalence agreement, you're not going to be that worried that if you get an assignment, you can't get attorney's fees, because you can do an offer of judgment 90 days after the suit starts anyway. So I think you're still going to see lots of these covalence style agreements. What I am seeing when people are doing covalence agreements anymore, almost nobody just does a straight out settlement. They typically do some kind of dispute resolution mechanism to let some neutral, like say Barry Davis, decide what the value of the underlying case is in a non-binding arbitration, or they go to a summary jury trial, or they do something so that it's not just a naked settlement that makes the amount of the settlement subject to attack on its reasonableness or honesty. I would tell you that's the biggest thing I'm seeing in these covalence, or as I prefer to call them, vouching judgments.
Which is simply an assignment of rights by the insured to the plaintiff for an amount of money and an assignment to sue the insurance company.
Yeah, and I have to tell you, in these bigger cases like FIU bridge collapse, and no one takes the chance of not defending. I mean, it would be economic suicide to not defend one of those cases. I'm not aware of a single carrier in either FIU bridge collapse or Champlain Towers that refused to defend outright. There were lots and lots of carriers that defended under reservations of rights, but nobody wants to receive $1 billion stipulated judgment on their doorstep. It would be foolhardy to not defend in a case like that.
And those are, again, some of the risks that go into the discussions that we have in advance of the mediation and in that risk analysis that's done during the mediation. Because keep in mind, the way I look at these mediations and the way we looked at it in those other cases is simply buying off risk. Nobody really knows what a jury's going to do. I can't tell you the number of times that I've had mock trials and I put 20 people listening to the same thing in a mock trial. And then you split them up and you put 10 in one room and you put 10 people in another room and you watch them through the one-way glass. And what happens is, I had one that I can remember specifically where the first 10 people came back with a complete defense verdict. It was in a quadriplegic case. And the other jury came back 4.5 hours later with a multi-million-dollar award. So you go, all right, now what? And you certainly get themes and that sort of thing. But I try to convey to people at the mediation that you're going to have either control yourself at the mediation to get it resolved, or you're going to turn it over to 6 people to decide your fate. And it's really going to depend upon what 6 people get into that jury box. And I think that that's really the driving force as to why these cases get settled, because of the finality and the control that you have. So next slide, please. Preparing for mediation. Timing issues. Somebody says, well, is it ready for mediation? And a lot of issues, both in these catastrophic cases as well as in the non-catastrophic cases, are taken into consideration. When's the trial? Is there a dispositive motion coming up? What about business issues? Is there a purchase of a company that's happening that would require all of these pending litigation matters to get resolved in order for the sale to go through? Is there a potential for bankruptcy, budgetary concerns, discovery issues? One of the interesting things that comes up from time to time is I don't have enough information. So the meeting, not me, but the parties don't have enough information. Keep in mind that insurance carriers or even corporations need to have information in their file to be able to justify paying money, either on behalf of the stockholders or on behalf of audits within insurance companies. And there's a number of times that we get into mediation and somebody says, well, I just don't have enough information. So we then use the mediation as a forum to be able to get the people the information on the plaintiff side or the defense side to be able to justify the payment of money. You're not necessarily going to have all the information because you'll only know that after trial and appeal. But that idea of having enough information and having the time to be able to make those recommendations and risk-benefit analysis to both the plaintiff and the defendant is very, very important.
I can't emphasize enough what Barry said. In my office, we call it feeding the beast. The insurance company decision-making process, I sue insurers now, but I used to represent them. I was a claims attorney. It's a very deliberative process. They want as much information as you can give them, and then they're going to assess the likelihood of winning, losing, defenses, mitigation, the likely ranges of damages, and they're going to make a cold mathematical actuarial decision about that. And they can't make that decision without good information, and they won't. And if you want to change the decisional path they're on, you can't do that on the day of mediation. If you've got something that you think affects the value of your case by millions of dollars, and you bring that to the mediation isn't going to be the place where that gets resolved. Now, can Barry use that and work the mediation process again, or call another mediation date, or work the phones? He can. But if you want that actual mediation to be successful, you've got to have given that information ahead of time. I always liken it to a battleship. An insurance company's decision-making process, they don't make hard 90-degree right angle turns. They take time to make sure that they don't make mistakes. Barry and I talked about this as we got ready. There was a study that was done by a combination of the ISO, and I want to say it was the University of Connecticut, kind of game theorying out, based on cases that were actually tried, what the insurance industry pays on their cases relative to their actual value as determined by other professionals. And the study showed that the insurance industry probably pays something like 50.5% of the, almost exactly in the middle of the range of outcomes of these cases. That tells me two things. It tells me that the insurance industry is really, really good at what they do if you give them the right information. And it tells me another thing. They're willing to pay. 0.5% doesn't sound like a lot, but if you think of the hundreds of billions of dollars of insurance claims that are paid every year, the insurance industry will pay a small premium to avoid nuclear verdicts over all of the risk that they handle. So the insurance industry knows what they're doing. Give them the information. They're probably going to make good decisions. That applies to your opponents too. Barry and I talked about this as we got ready. Barry and I were often on the same sides, but sometimes we weren't. We were on opposite sides. I like it when there's good lawyers on the other sides of these cases, because good lawyers know how to analyze risk. It's people that don't know their practice area that act like, that are irrationally exuberant about the kinds of outcomes they can achieve in litigation. I'll say it that way. I'd rather somebody understand how to assess the risk. That probably means the case will settle.
Well, that goes right into our next slide, Kathy. It's important to understand the player personalities and not just the lawyers. Yes, having the good lawyers that come to the mediation and being prepared with our confidential pre-mediation calls to get their perspective is very important. But also understanding the clients, because sometimes clients do come in with irrational expectations. And many times, particularly when there are levels of mediation and, levels of coverage, I'll ask the defense lawyer, may I have a call with you and the clients? And many times they'll agree to that, where we get on a pre-mediation call and I'm talking directly to the decision makers in the insurance world or at the corporation or even with the plaintiff. So you know who the people are that you're dealing with, the way they think, what their goals are, and being able to then share that and read between the lines when you're going into the mediation of who you're dealing with. Because sometimes somebody doesn't go into it with understanding those risks. So really it's the lawyer's job to explain those risks to the client, but it's the mediator's job as well as a neutral to explain that on both sides. So trying to know who the people are, and that was part of the thing we did in the FIU case, is that I had to figure out who the real decision maker was and who had the gravitas to be able to deal with other plaintiffs' lawyers, other defense lawyers, and the various carriers and the people. And that took a while to understand where each person was coming from, how educated they were, how experienced they were, to know that you then had people coming into the mediation who were really prepared, understood the issues, and understood the risks. So that's a good part of what we did in those catastrophic matters, and what we do in regular cases that aren't catastrophic is to understand who the players are and the personalities.
Yeah, a lot of my practice, the overwhelming majority of my practice is the representation of Fortune 500 companies that can make the same kinds of actuarial mathematical decisions, think about how much it's going to cost to litigate versus what you're going to get out of it. What are the chances of winning and losing? Somebody said what my job is. I'm like, well, I represent one Fortune 500 company. They're suing another Fortune 500 company, and one of them is going to have a worse Sarbanes-Oxley report on the next quarter. But when you have these cases where there's more of a personal element, there were 98 deaths in Champlain Towers, and I heard some just impossible stories that would bring you to your knees with tears. And we heard some of those in FIU bridge collapse. Barry will remember there was this one young girl, the one that I always remember, same age as my daughter, that was trapped in her vehicle and basically slowly perished underneath the weight of the bridge. When you have those issues, or even I represent a lot of wealthy folks on their single family homes, they're not all going to make their decisions based on actuarial decision making. And it's very important for you, if you're the defendant, to communicate with them in a way that doesn't create more animus. And it's really important that you have somebody like Barry that can be the grandfather that goes into that room, or the grandmother, and goes, okay, what happened to you is beyond the telling of it, but we're going to help you make the best decision you can for the circumstances your family's in. You better have a good mediator to have that discussion with the family.
Well, that brings me to the next slide in preparing for mediation. Kathy. I'll go to the next one, please. One of the things that I always found in being the trial lawyer and now being the mediator for the last few years is that the mediator has the opportunity to go into the other room and read between the lines. So when somebody tells me, could you please keep this confidential, but this is where we're headed, and what do you think as to what we should do next? That to me is that trust is something that's very appreciated and taken into very seriously in making sure that I keep that trust. So I get to know the plaintiff, I find out really what they're about, and then when on the other side, the person with the money, the decision maker, I ask them about themselves. Because I think too often people just treat the insurance representative as somebody with a checkbook, but I try to get to know them. I want to get their trust. I want them to ask me, what do you think we should do next? I want them to tell me where they're going so I can keep it in the back of my head in being able to go back and forth between the rooms. Because really, the mediator is the only one that can see what's going on between the rooms. And to the extent that I'm given the authority to share those things, to the extent that I can see how people are acting in those rooms, helps to get the matter settled. So your comfort level, if you can trust the mediator, whether it's me or somebody else, and being able to convey that, really goes a long way towards trying to get it resolved. But you're the one who has to have that comfort level, and that's really something that's earned. So Kathy, next, please. In controlling the mediation, the goal is for the parties to really learn the thought process of what's going on in the other room to the extent that that room authorizes it. So what we try to do, and what we try to do in these catastrophic cases as well, next slide, is to simplify things, the judge, the juror themes. And we ask, what are those things that are really at risk? Because you're going to have 6 people who probably have a combined 8th or 9th grade education deciding this and won't understand, no matter what's done, the depth and the details of what we as lawyers or mediators understand. So how are you going to create that risk to be able to bring to the other side the credibility issues, the exposure issues, those sort of things? Because all mediation really is, when you get down to it, is buying off risk. That's plain and simple. That's all it really is. So my suggestion is think about your top 4 or 5 best themes, because at the end of the day, that's all the jury is going to decide a case on. So what is the next slide, Kathy? What we look for as mediators is, in reading between the lines, what are the words that are being said? Is it consistent? Is there variability in the words that are being said about where they intend to go? How many times in doing the negotiations is the same midpoint coming up? What about the use of brackets? And what's that telling us? And then the extent to which you getting that on both sides is going to tell you as you go along, not to guess what's reading between the lines when the negotiations start, but the more and more information that comes to light, the more and more, as a mediator, you can get that better view of how the parties are coming together, whether it's here, whether it's here, whether it's here, or whether there needs to be an adjournment to be able to let those things settle in and try to get it done. Mark?
I teach the lawyers in my office that a mediation can be successful even if you don't settle, as long as you've got a good framework for where the other side is. It's in the nature of negotiating that they're never going to let you know exactly what they'd be willing to do in most circumstances. Nobody wants to lose their positional or bargaining advantage, is what they call that in dispute resolution school. But your mediation can be successful even if you don't settle, if you have an understanding of where your opposition is. And you at least got to work the process enough to find out as much about that as you can, because that's going to tell you about where your risk buy-off point is. I think Barry is exactly correct. All mediation is another form of risk management. And the real issue you've got to figure out is, if you can't settle the case, what's it going to take to do it? Because no matter which side of a case you're on, as lawyers, it's your job to communicate that to your client so they can make the decision. As lawyers, we just advise. A second rule in the bar rules is the client decides.
We have about 6 minutes left.
Thank you, Kathy. Next slide. There are ways of testing the intentions of the parties. Anybody can declare an impasse at any time they want. But sometimes people say, I'm going to declare an impasse if, and then you got to test that. And there are ways to test it, such as if you make a substantial move, I've got the authority of the other side to say they will do the same. Not dollar for dollar, just a substantial move. What a substantial move means, it means if I can truly sell it to the other side as having made a substantial move. And I'll tell you if I don't think it's substantial, because I can't sell it. So those are some of the tests, the bracket issues, the mediator's proposal, and there's quite a number of them.
Barry, talk about the mediator's proposal and whether you like it or you don't like it. Do you like to be the one that brings it up? Would you rather have the lawyers bring it up to you? What's the circumstances in which you feel comfortable as the mediator doing the mediator proposal?
The mediator proposal is simply where,
maybe tell the folks what it is for those who maybe don't use it.
yeah, a mediator proposal is when you start to get close and people are saying, I'm not going any further, I can make a proposal with a number that I share with each party. And I say, look, if you accept it, I'm not going to tell the other side unless they accept it. So if you say no, you don't know if you say no whether the other side had said yes or no. So you don't lose anything if you said yes, because the other side will never know what you did if they say no. And I say I don't particularly like them because I'd rather have the parties making those decisions. But on a rare occasion, when the parties are starting to get close and I feel comfortable doing it, I will do that, making that mediator's proposal. And it typically works, but only in the right circumstance and only towards the end. We're almost done. So we will answer questions and answers after the mediation, as Kathy said. We were asked a couple of questions. So I mentioned that, Kathy, about when is an impasse an impasse. Everybody can say it, but it isn't an impasse until everybody says it is, because a lot of times that's just part of a negotiating tactic. So the parties persist unless somebody wants to get up and leave, which they can. So I typically test that and say, do you want me to tell the other side that that's it? I'm drawing a line in the sand. There's not going to be anything further. And a lot of times there's a little bit of hesitation, and that's where the door is there with the little light coming out of the door. So we continue to pursue it until the door is actually shut. Keep going. We'll go quickly. Resolution, avoid an unraveling of a settlement. Sometimes there's a follow-up where the mediation is adjourned and the phone calls are made. Sometimes lawyers say, well, let's get another mediation set or another conference, because all the lawyers and mediators, most of them or many of them, are busy. And so if you lose the focus, I always recommend let's set the date for the follow-up or the date for the calls. I also recommend very strongly that the parties themselves sign the settlement that day, the mediation agreement that I send around by Adobe Sign, because there are recent cases that say, even if you have a confirmation from the lawyers saying, we the plaintiff agree, or the defense, we the defense agree, if a party then says, I didn't agree, the judge really has no discretion and must set aside the settlement.
This is really important. There's two cases right on point, including a newer one, as Barry said. The absence of a signature from one of the parties is fatal. If the rule says the lawyers have to sign, there is a case that says the failure of the lawyers is not dispositive if the clients in fact have signed. But that absence of a signature from a lawyer, at least on your, or from a client, at least on that term sheet, is probably going to cost your settlement, especially if you have a squirrely claimant.
Anyway, I think we're out of time, but Mark and I are happy to answer any questions that are submitted. We had a number that were submitted prior to the mediation. So we encourage you to submit those questions. We will be happy to respond, and have a wonderful day. Kathy?
Thank you, Barry. And
thank you, Mark. It's always a pleasure.
If you're a Florida attorney, please jot down the Florida bar course number so you can post your CLE credit online. It is 2302995, N as in Nancy. Again, that's 2302995, N as in Nancy. We're building out our webinar schedule for the remainder of 2023. Please watch your email inbox for news about future programs. The next is Special Litigation Committees and Limited Liability Companies with Don Widener on May 25th. Here's the contact info for everyone. Barry, Mark, and myself if you have any technical questions. Thanks, everyone.
Thank you.
Thank you.